Thank you everyone for being here. My name is Maggee. I'm from the Minnesota Catholic Conference. I'm one of the policy associates here. And today we are joined by, of course, Teresa Collett from the University of St. Thomas and the pro-life center there. She works as a professor at the law school. And then also by Renee Carlson from True North Legal, which is an initiative of the Minnesota Family Council. So as Teresa mentioned, people are still joining, but that's okay. We're going to go ahead and get started. We have a great presentation, hopefully for you today, but some of you, I know we did this in late May, early June. You were on last time. We asked that if you guys have questions, feel free to send those in when you have them or as you have them. And then we have some time allotted at the end where we will go through and try to answer as many as we can, but don't hesitate to start asking them as early as they pop in your head so you don't forget them. Thank you. And Teresa, I'll hand it over to you.
All right. Well, thank you very much. I'm going to share the screen again as we did last time. You will be able to see some of the slides that look familiar from our last presentation, just as a review for those who were with us last time. And for those of you who weren't able to make the last webinar, this may be some new information. We certainly want to give the proper background. So with that, let me begin with the first slide. As many of you already know, last legislative session was momentous, particularly when we're talking about things like the protection of human life. Sadly, probably our next legislative session promises to be equally momentous, and we'll talk a little bit about that at the end. But it does seem like, as evidenced by the fact that what's called the PRO Act, Protect Reproductive Options Act, was Bill number 1, House File number 1, and Senate File number 1. It seems like the major focus of our legislative session that just ended is, of course, abortion and removing anything that the abortion industry perceives as a restriction or limitation. So during that session, they passed the Protect Reproductive Options, that is the PRO Act, the Reproductive Defense Freedom Act, and then an omnibus bill that contained multiple things, which includes eliminating the positive alternative grants, increasing abortion funding, eliminating the reporting of deaths related to abortion in the state, and the reporting of children born alive during an attempted abortion. It eliminates reports of state funding of abortion performed on women out of state. Let's just look at them very quickly. The PRO Act, again, as a reminder, was supposed to, quote, establish the fundamental right of Minnesotans to make individual decisions about reproductive health care, including contraception, abortion, and pregnancy. And it passed so that we now have a statutory right that is characterized as a fundamental right. But of course, fundamental rights are typically constitutional rights or rights that arise by natural law. And the Supreme Court to date here in the state has not characterized it as a fundamental right per se. But the legislature has certainly weighed in and argued that it is and should be by virtue of passing this particular piece of legislation. The Reproductive Freedom Codification Act was an attempt to repeal abortion restrictions, including the two-parent notification law. They were unsuccessful, one of the few wins for the pro-life folks. But they also were successful in repealing our 24-hour delay, as they call it, or the waiting period for people seeking an abortion, as well as the requirements of informed consent. They also were successful in eliminating funding for the positive alternative grant. So again, the PRO Act, we became the 16th state to explicitly protect abortion in our state law. We already, of course, had Doe v. Gomez, a state Supreme Court opinion that created a woman's decisional privacy right to choose abortion. And as a consequence of that, the Supreme Court ruled that the funding of abortion must be comparable to the funding of prenatal care, not in amount, but in accessibility for those who are unable to pay directly for their medical care. It also statutorily recognizes abortion without any limit on viability. Now, honestly, that was no change in the law, because early on in 1974, the year after Roe versus Wade was decided, the federal district court here affirmed on appeal, ruled that our state post-viability ban was vague and therefore unconstitutional. So the state of Minnesota has not had any durational limitation on abortion since 1974, although it is something that a significant majority of Minnesotans, according to public opinion surveys, support. The PRO Act also defines reproductive health to mean healthcare offered, arranged, or furnished for the purposes of preventing pregnancy, terminating a pregnancy, managing pregnancy loss, or improving maternal health and birth outcomes. But here's where it becomes vague insofar as not really knowing the full scope of the act. Reproductive health care includes, but is not limited to, contraception, sterilization, preconception care, maternity care, abortion care, family planning and fertility services, and counseling regarding reproductive health care. The reason I say it becomes vague there is, the statute says reproductive health care includes, but is not limited to. So they've left the door open for judicial interpretation that would encompass transgender care, that would encompass sex reassignment surgery, etc. So we don't really know the full extent of this law at this point in time. The litigation has not commenced. Reproductive freedom, as they define it, every individual has a fundamental right to make autonomous decisions about the individual's own reproductive health. Again, that long litany: contraception, maternity care, abortion, sterilization, including but not limited to, but including the fundamental right to use or refuse reproductive health care. Every individual who becomes pregnant has a fundamental right to continue the pregnancy and give birth. That's an important concession to the fact that many women, most women across the country, choose to continue their pregnancies or to obtain an abortion and to make autonomous decisions how to exercise this fundamental right. By the phrase autonomous decisions, of course, they are seeking to echo or incorporate the concept of Doe v. Gomez, that a woman should be entitled to decisional privacy when deciding whether to continue or to terminate her pregnancy. The Minnesota Constitution establishes the principles of individual liberty, personal privacy, and equality. Such principles ensure the fundamental right to reproductive freedom. This is a much broader statement than we find in Doe v. Gomez. And while it is true that legislators regularly have to make a judgment about whether proposed legislation is constitutional in accordance with the state and federal constitution, it is typically the courts who make the decision about the scope of these freedoms. So the exact legal status of this subdivision 4 is certainly open to debate. They do, however, make clear that local units of government may not regulate an individual's ability to freely exercise the fundamental rights set forth in this section in a manner that is more restrictive than set forth in this section. What is that about? It is because we now have roving abortion pill clinics in the state, something, of course, that the current administration called for after the Dobbs opinion. We have these mobile clinics, if you will. There are some towns and cities and even counties that are reluctant to have those particular services offered in the manner in which they are through a mobile clinic. And we're considering restricting those sorts of mobile clinics, the Just the Pill clinic, for example. This particular portion of the bill precludes the ability of locations, cities, towns, counties from making such a decision. The omnibus bill, and we'll hear a little bit more from Maggee on this, repeals the Positive Alternatives Act that has provided practical assistance and support for tens of thousands of pregnant women and new mothers in communities across Minnesota. It repeals part of Minnesota's reporting law, including the requirement that abortion practitioners report cases in which infants survive abortion and whether those infants received care. 5 such cases were reported, according to the Department of Health in its last report in 2021. We'll hear a little bit more about that, particularly this being an important part of Minnesota Concerned Citizens for Life's objection to many aspects. It increases reimbursement rates for tax-funded abortions by 20%, with almost 25% of that going to Planned Parenthood. Now, notice in most industries where you would have a state funding situation that excludes the ability of any other providers to participate, that would be a problem. But here in Minnesota, apparently, we only want the funding for those providers who almost exclusively provide abortion. And we've eliminated the funding for those agencies and private organizations that supported women who wanted to continue their pregnancies, the pregnancy assistance centers. Again, we'll talk about that in a few minutes. Repeals other things like women's right to know, which is an informed consent statute that was, in fact, unique to the abortion setting, but that is because abortion itself is unique. There's almost no other non-emergency medical procedure that you can go into the doctor's office and have that procedure provided to you, especially surgical procedures, provided to you right then on the spot on that day. And so in this instance, it seemed important to have a waiting period. It also seemed important for women to consider the information that was required. There are also almost no sort of medical procedures that are done out of an economic concern. And we know from the Minnesota reports on why women obtain abortions that a great number of women are, in fact, concerned that they simply cannot support another child. And so part of the women's informed consent requirements were that they needed to be told about state assistance programs and private agencies that might be able to help them continue their pregnancy with any medical expenses or other expenses related to their care. So let's turn first to something that's having a fairly dramatic and problematic issue here in Minnesota. They defunded the pregnancy assistance centers, notwithstanding the fact that crisis pregnancy centers outnumbered abortion clinics 11-1 in Minnesota, but not, of course, to the scope and magnitude of the funding of the abortion clinics. And with that, let me turn it over to Maggee to talk to you about what the impact has been.
Thanks, Teresa. So as Teresa mentioned, the Positive Alternatives Grant was repealed this session. I know many of our listeners probably know that. Many of you are affiliated with pregnancy resource centers. So the grant received nearly $3.5 million in funding per year. It went to 27 different pregnancy resource centers in this current cycle. And they're at, I think, 32 different locations. And the grant, so it ran on a 5-year cycle. The recipients were expecting to have the money through 2025. So they not only lost the money for this year, but they lost money that they were depending on for a few more years yet. So it's put their budgets, kind of turned their budgets upside down. And we'll point out this wasn't necessarily an economic decision by the state. They had a historic increase at $18 billion surplus this year. They have a $71 billion budget. So there's a lot of money going around from the state to many different organizations and agencies and things. The $3.5 million that was allotted for the positive alternative grant accounted for 0.00005% of our budget, our state budget. So definitely not a huge amount. It was a drop in the bucket, but for the state, but a huge support to our pregnancy resource centers. So losing that, I know, is quite difficult for a lot of them. And for many of the grant recipients, just from my conversations with them, and we asked some of them what the impact was, a lot of them, it was about 50% of their budget, some more, some less. And so if you lose 50% of your budget mid-year, that's pretty tough. Based on what they said, some of them have had to cut paid staff. Many of them have had to cut their marketing budgets back significantly or altogether, decreasing the amount of material support they're able to give. So, for example, the number of diapers per week. Some are looking at different crib distribution and car seat distribution things, and maybe having to cut some of that back, limiting their class availability that they offer for mothers and families. Some are having to decrease their ultrasound availability, which is a huge loss to the women who come through their doors. And others are even having to cut the number of hours that they're open. So without, half your budget, it's pretty tough to be able to serve at the caliber that you were. And there are a number of PRCs from what we've learned that are able to get by this year, but looking at 2024, without a big boost in donations or a big enough boost in donations, they might have to make some more tough decisions. So these are just some preliminary things they're doing to try to get by, and then having to look at what's next, how do we sustain going forward. And pregnancy resource centers are really the heart of our movement. They're on the front lines helping women. So I know we see this as a huge loss, as do many of you.
Thank you, Maggee. And so, in fact, we need to perhaps mention that these cuts, especially the marketing, means that it's going to be hard for women to find a pregnancy assistance center in their community. The cuts in paid staff, those are the folks who partner with the women and walk with the women as they learn new skills. They learn parenting skills. They learn about child nutrition. They learn about a number of important things that will help them in their role as a new mother. And yet now, that's not going to be available to these women. And these are services that, in reality, Planned Parenthood and other abortion providers simply do not provide to women. So it's going to be very, very difficult for pregnant women who don't have all the resources available to them that some women have to make the choice for life. So let us continue. Oh. Thank you, Maggee. Let's talk also for just a minute about the repeal, which is something that's very concerning. In fact, last session, we had a number of questions about this. Minnesota now has taken the position that we no longer believe that the infant who is born alive through the process of abortion should receive all reasonable medical care in order to sustain its life. This is actually, this shot that you're seeing, this is the bill itself. So this is what it looks like. The strike-throughs mean those provisions are eliminated from our statutes. An infant who is born alive shall be fully recognized as a human person and accorded immediate protection under the law. All reasonable measures consistent with good medical practice, including the compilation of appropriate medical records, shall be taken by responsible medical personnel to care for an infant who is born alive. Now, notice that change, because at one level, it doesn't look very invidious. But in fact, at the time the legislative committees were hearing this bill that became law, a nurse came forward who recounted her experience as a young nurse in a surgical suite where a child was born alive. And the woman asked about the child, and the doctor told her the child was born dead. In fact, according to the nurse, the child was handed to her and she was instructed to leave the operating theater and to simply give passive or what's called comfort care to the child while it slowly died with no sustaining medical care. That was, of course, the point here, was to require that medical personnel take appropriate measures to preserve the life and health of the born alive infant. The purpose was not to mandate it where, let's say, that the child is born alive, but in such a condition that its life can't be sustained. But we know from various abortion survivors that there are children increasingly who are born alive during this process and who survive and actually in some instances can thrive. Data shows from the Minnesota Department of Health that every year some babies have been born alive in the context of abortion. Again, in 2021, the last reported data, there were 5 infants that were born alive. Lawmakers who voted to repeal that right in 2023 claimed that the repealed language required inappropriate or futile attempts to save pre-viable infants' lives. According to the Minnesota Concerned Citizens for Life, that's false. In truth, the repealed law simply required reasonable measures consistent with good medical practice, as we just saw from the prior slide. And after the recent actions of the legislature, newborns are no longer guaranteed treatment that would save their life. This will be an area also where litigation could come forward, possibly, where a woman hears the cry of her child and, notwithstanding that she originally was seeking an abortion, wants the child's life to be sustained. So that's sort of a review of the legislative session, some of the harmful things that have happened. What's happening in the courts now? Well, I wanted to give you an update on Doe versus Minnesota. As many of you know, last year, the Ramsey County District Court determined that many of the Minnesota abortion laws were unconstitutional under Doe v. Gomez, the Minnesota Supreme Court opinion creating this right to abortion. Among them were the women's right to know, a hospitalization requirement, a limitation that abortion be performed only by physicians, something that, of course, is particularly important if it's a surgical abortion, since nurse practitioners and midwives certainly don't have adequate training to deal with certain surgical complications that could arise. And yet, the Minnesota Ramsey County Court said that those laws violated the woman's decisional right to privacy. Of all of the laws that were struck down, the vast majority of them were repealed this session, as we mentioned in that first and second slide. But one managed to survive, and that exception is the Minnesota requirement that an abortion provider inform both parents of an intention to perform an abortion on the parent's minor daughter. So in this particular case, the trial court ruling on multiple occasions noted that the Attorney General and other government defendants presented no evidence regarding the interests that were being advanced by the particular piece of law that was being challenged. So, for example, one of the allegations of the plaintiffs and statements of their experts indicated that a minor girl, regardless of age, who is pregnant and who desires an abortion has the same decision-making capacity that an adult woman has. Now, those of you who are watching this, who are parents of teenagers, know that that's simply not the case. And we also know that the law, in general, doesn't presume that. In fact, that's why we have a whole elaborate set of both laws and procedures to protect minors. We have the juvenile justice system, where minors are treated differently than adult defendants are. We also have laws that eliminate the ability of minors to enter into contracts, to enter into marriage, to enter into any number of other decisions, for the simple reason that we know they simply are not mature enough to make the sort of reasoned decision that an adult would make. Notwithstanding that fact, the Attorney General provided no evidence on the decision-making capacity of minors. Because of that, of course, the trial court had no evidence rebutting what the plaintiffs were saying, and it struck down the two-parent notification law. A group of Minnesota mothers with minor daughters came together and formed an organization called Mothers Offering Maternal Support. That organization then retained me as their lawyer in order to try to intervene in the case and to reopen the case for purposes of actually putting in evidence that established that minors do not have the same decision-making capacity as adult women, that minors are more likely to be subject to coercion in these sorts of settings, and that there are many other benefits that come from a parental notice law, particularly, for example, if the pregnancy is the result of some sort of sexual assault or human trafficking. The trial court, after reading briefs and hearing oral argument, denied moms the right to intervene in the case on the basis that he had already issued an opinion. He thought the attempt to enter into the case was not timely. He also asserted, in his opinion, that the Attorney General's defense of the parental notification law was adequate and was sufficient to protect mom's interests. Now, we know that when you present no evidence at the time of summary judgment, the outcome is preordained. So to the extent that ruling is inconsistent with the court's own ruling that there's no evidence in the record regarding the need for and the utility of a parental notification law, we are optimistic that the Minnesota Court of Appeals will disagree. That appeal is now before the court. All of the parties have briefed. Moms, of course, as the party, the petitioner in the case, had the opportunity to set our case forth first. Responsive briefs were filed by both the government defendants, including the Attorney General, and by the abortion providers in this case, and the abortion financier, who were the plaintiffs. And both the government defendants and the abortion providers and financier objected to mom's participation and continue to argue that mothers have no right to try to intervene and try to provide evidence to the court of the great benefits of parental notification. We are now simply awaiting an order from the Minnesota Court of Appeals to set the date for oral argument, at which time the court will then have a limited period of time after that to issue its opinion. But that's not the only case that's in the Minnesota courts right now. And I'd like to invite Renee Carlson now to walk us through another important case that relates not only to abortion, but to healthcare providers' conscience rights. Renee?
Thank you, Teresa. Well, hello, everybody, and welcome. Thanks for being here with us today. Teresa's right. There is another important case actually in the Minnesota courts. It's actually in the Court of Appeals right now, and I'll give you a little bit of that background. So this is Andrea Anderson, the Aiken Pharmacy Services. Andrea Anderson is the plaintiff who sued both Thrifty White and George Bordeaux, a pharmacist, in his individual capacity. And she sued him for sex discrimination under the Minnesota Human Rights Act, alleging a discrimination in violation of the public accommodation and business protections in the Minnesota Human Rights Act, simply because the pharmacist acted consistent with his conscience-based beliefs under the law not to be complicit with abortion by not dispensing an abortifacient, that prescription drug, Ella. So, of course, the Minnesota Human Rights Act protects people based on various categories, including sex, which also extends to pregnancy. And ironically, this protections also extend to religious people as well. So some important background on this case, because as I said, it is at the Court of Appeals, is where it was at previously before it went to a jury trial, and some of the facts that led to that. So essentially, Andrea Anderson got a prescription for Ella, and she sent that to the pharmacy, the Thrifty White Pharmacy, and asked for it to be filled. It's my understanding, according to the facts, that it was not in stock at the pharmacy. And when pharmacist George Badeau learned what that prescription was, he had actually never heard of Ella before. He looked it up and realized that it was an abortion-inducing drug, and that to dispense it would be in violation of his conscience. So he got in touch with Anderson and let her know that not only was the prescription not in stock, but that he, as a pharmacist, couldn't dispense it, but would be happy to help her get it from another pharmacy. That did not go so well, and eventually Anderson ended up getting this prescription filled at another pharmacy. The interesting part is that although Anderson tried to make arrangements, Bordeaux tried to make arrangements, he also warned Anderson about an interesting fact in this case, which was an imminent snowstorm. So again, this prescription was not in stock. There was no way to get it to this rural location of this pharmacy any sooner than likely the next day. And perhaps this would be the case for any pharmacy in the area, but essentially Bordeaux did not have a chance to be able to make those connections because Anderson pursued other options in getting the prescription elsewhere, which was about 2 hours away. She ended up again suing the pharmacy and the pharmacist in his individual capacity. And so again, this decision not to dispense Ella is protected based on rights of conscience in Minnesota. And we'll go to that next slide. Maybe. Thanks, Teresa. So True North Legal and the Minnesota Catholic Conference have submitted a briefing in support of rights of conscience and in support of the pharmacist in this case at the Minnesota Court of Appeals. And again, just to reiterate the arguments there, go back one, Teresa. Yeah, is that Anderson's arguing that refusal to provide abortifacients is essentially sex discrimination under the law in violation of the Minnesota Human Rights Act, while pharmacist Bordeaux is arguing that he did not commit any sex-based discrimination because his reason for not providing this abortifacient is based on his sincerely held religious beliefs that dispensing Ella would be in conflict with and force him to be complicit with abortion. And so it's very important to understand that the issue here in this case is not about a person or their status. It's about what Ella does. Ella destroys a uniquely distinct new human life. And there are many reasonable people who object to dispensing abortifacient drugs that will kill an embryo, an innocent human being, that will kill an innocent human life. And that is the reason why George Badeau objected to dispensing Ella. The good news, as we see it, and as we wrote about in our briefing, is that the rights of conscience is strongly protected, both under the Minnesota Constitution and Minnesota case law, as well as even federal law, as most of you are probably more familiar with. But I'm just going to make sure that you are familiar with our strong protections in Minnesota, first and foremost. The Minnesota Constitution says that in Article 1, Section 16, the right of every man to worship God according to the dictates of his own conscience shall never be infringed. Not only do we have those explicit protections in the Minnesota Constitution, but we have courts in Minnesota that have held that this language protecting rights of conscience is even stronger. Yes, even stronger than the federal constitutional protections for rights of conscience. And this interpretation has been applied in cases where there's a tension, as we have here, between the rights of conscience and the protections afforded in the Minnesota Human Rights Act. Two cases that we mentioned in our briefing are very important and illustrate this. For example, we talked about a case called Rasmussen, where a deli owner's religious beliefs regarding abortion precluded the state from forcing him to deliver food to a clinic that provided abortions. And then we also mentioned and fully discuss a case called French, where the Minnesota Supreme Court upheld a defendant's right not to rent to a cohabiting unmarried couple because of his religious beliefs and the concern that that may portray his acceptance of something that he didn't believe in, again, based on his religious beliefs. And of course, many of you are probably familiar with the First Amendment of the United States Constitution. I hope you are, which also affords strong protections for individuals' rights of conscience, even in the context of the varying views about abortion. And many of you also might be familiar with the Hobby Lobby case. We also raise this as well, which is a very significant case with respect to what's happening here in Minnesota. In fact, the Supreme Court held in the Hobby Lobby case that the government cannot mandate corporations to pay for abortion-inducing drugs, which at that time in that case included Ella. So you can go to the next slide, Teresa. Now, this is this case that we're talking about here in Minnesota is interesting because it is illustrates the conflict between the Minnesota Human Rights Act and a person's right of conscience, particularly a provider and a pharmacist. And we're used to seeing these types of cases where perhaps a medical provider or a pharmacist asked for an accommodation based on their religious beliefs. They'll ask not to do something. Maybe it's providing abortion-inducing drugs, gender transition surgeries, or even dispensing pharmaceuticals, and they will approach their employer and explain how that action may conflict with their religious beliefs, and then ask to basically have an accommodation or be excused from doing so in the context of their employment. And then the employer will have to evaluate whether there is a hardship and go through kind of a series of evaluations with HR and under the law as to whether they can excuse this person. And I'm excited to tell you that there is a recent Supreme Court case called Groff v. DeJoy that has to do with this very thing. It's where the Supreme Court examined the religious accommodations under Title VII, and it really is encouraging because it strengthens the Title VII religious accommodation protections for pharmacists and medical providers. So the facts in that case were that a postmaster named Groff had been hired by the post office and was an extraordinary employee. He was going above and beyond all of his expectations when the federal government contracted with Amazon, and suddenly he was asked to deliver packages on Sundays. Well, he had strong, sincerely held religious beliefs about the Sabbath and said that he simply could not deliver the packages on Sunday, but could make all kinds of other accommodations for employees to make sure that his schedule still was what the post office wanted and he was doing his job, but yet he was also not forced to violate and acknowledging his commitment to God, not to violate the Sabbath and to honor it by not working on the Sabbath. The Supreme Court had to examine how employers will evaluate an undue hardship, because we have seen that there has been some hostility towards people of faith and towards people who are asking for religious accommodations in the workplace, to the extent that some employees were actually abusing the undue hardship standard and again, exhibiting some hostility towards people who are asking for religious accommodations, and this is discriminatory towards people of faith. So essentially, in the Supreme Court's analysis, they re-examined what is an undue hardship, and they specifically said that no undue hardship is imposed by temporary costs, voluntary shift swapping, occasional shift swapping, or administrative costs. So in other words, businesses cannot rely on incidental burdens as a basis to refuse or honor an employee's request for an accommodation. So again, I just offer this as a note of encouragement. While the Badeau case is not a Title VII case, it does give us some indication about where the courts are headed with respect to religious liberty protections and those religious accommodations for medical providers and pharmacists under Title VII. So viewers, I hope that you are encouraged by that news and that you're encouraged to know that groups like True North Legal and the Minnesota Catholic Conference have been engaged in support of amicus briefs at the Minnesota Court of Appeals in that Badeau case, and we are constantly monitoring our rights of religious freedom and conscience protections in Minnesota.
And in fact, Renee, my experience has been that I've had a number of nurses and even doctors on occasion reach out to me where their medical practice group, at least for the physicians, is insisting that they prescribe abortifacient contraception. And so certainly under Groff now, Would you agree that their protections under Title VII are much more secure?
Yeah, I would. I think it's a much stronger protections. And even prior to Groff, True North Legal has helped other providers who have been in those situations. And sometimes you just need to have a conversation with your employer to let them know how strong these protections really are.
And I think that's an important note of hope. Maggee, you also had indicated that there's some other good news. As I've titled this slide, the good news, the U.S. Supreme Court are stronger now as a result of this decision. Groff is good news for those who want to act consistent with their religious-based protections by not being complicit in abortion, and arguably including pharmacists. But before we get to our questions, let me stop the sharing. Maggee, there was other good news this legislative session too, wasn't there?
Yeah, there was a few other good things that happened on the life front. You mentioned one of them. They did not repeal the parental notification as is, though it's in the courts. So that's good that we still have the opportunity in the courts. But other things that they did were a little more unique. They created or bolstered a diaper distribution program. So that's another way they're working to help women in need. They implemented a child tax credit, which helps families. So that will be an ongoing credit to lower income families. We're working on expanding that to reach middle income as well, but another support going to our families in need. And they also instituted handicap parking passes for pregnant women. If they have any complications or things, they can get a handicap pass later in their pregnancy so they can park closer and have less time to walk, which is nice. And then one thing we didn't get across the finish line, but many people who came to United for Life would have advocated to eliminate the state sales tax on some of the necessary baby items like cribs, car seats, wipes, and more. And we are still working on that one and hoping that that passes in 2024. So there were still good things on the life front, even though most of the guardrails got struck down.
So if a woman is really insistent on carrying her pregnancy to term, there are some helps available to her now, sadly not through pregnancy assistance centers, but we can't say that there was no concern for those children who are actually born alive, as long as they weren't born alive during an abortion.
Right.
Okay.
Yeah, they removed that funding to the pregnancy resource centers, but they did do other things, which is good.
Renee, other comments or reflections on this past legislative session?
I think that it was encouraging to see multiple people turn out at the United for Life rally, even after the passage of the PRO Act. So I think that that should be an indicator to not only legislators, but just to the general public and Minnesota citizens that the pro-life movement is alive and well. And while we are facing some discouragement and an uphill battle on the right for life, I think we need to keep moving and keep fighting and showing people why we care, why we have unwavering support for preborn children and for their moms and for families.
So I know Maggee had said that we wanted to end on a happy note, but I'm going to shift it just a little bit. I saw an announcement or a newspaper article recently that one of the legislative items for next year is going to be the passage of aid in dying or assistance in dying. How I know the Pro-Life Center is gearing up for that fight. It's not the first time we've had this conversation in Minnesota, and we're certainly expecting to participate in that conversation. But are there other things that we need to be concerned about coming up? Maggee, I'll go to you first.
Yeah, I think the physician's assisted suicide is definitely a big piece. If people are interested in that, we have another coalition, the Minnesota Alliance for Ethical Healthcare. And so if you're interested in that issue, they have education that they offer and different things, willing to come speak at for your organization. So definitely look into that. And we also offer healthcare directives here at the Minnesota Catholic Conference, a Catholic healthcare directive. So if you need that, you can reach out to us. And then the other piece that I would add, and maybe Renee can jump in on this, is the Equal Rights Amendment. Teresa hinted at some of this just a little bit with the PRO Act and the implications of that, but we will, I would say, certainly see the Equal Rights Amendment, which we oppose and the others oppose, coming down the pipeline early. Renee, if you want to jump in there.
Yeah, we did see a little bit of that last year with the Equal Rights Amendment coming up at the end of session, and it's been stated publicly in the media that that is a promise to try and push that towards the finish line. So that we'll have to pass the House, and if it does, then it will go on the ballot in November. So I think we're gearing up for some big time education efforts to help people understand that this is not your grandmother's Equal Rights Amendment. This amendment, or so-called Equal Rights Amendment, is not about equal rights for women. It actually abolishes the rights of women by allowing such things as men being able to be in women's private spaces. That even includes in women's prisons, vulnerable places like that. So this is actually intruding on and violating the rights of women under the so-called Equal Rights Act. And of course, and Teresa can chime in here as well, but certainly expands the protections for abortion rights in the courts as well, by giving the courts kind of a blank check, being able to rely on a constitutional protection for those rights.
And I think it's really important, as Renee has mentioned, that this is not your grandmother's ERA. And in order to show you that, let me share my screen again. This is what the proposal was for this session. As viewers can see, the proposal was an amendment to the Minnesota Constitution, which would read, "Equality under the law shall not be abridged or denied by this state or any of its cities, counties, or other political subdivisions on account of race, color, creed, sex, sexual orientation, gender identity or expression, age, disability, ancestry, or national origin." Now, what will show up on your ballot would be the question, shall the Minnesota Constitution be amended by adding a specific guarantee of equality of rights under the law, shall not be denied or abridged by the state or any of its cities, counties, or other political subdivisions, again, on account of race, color, creed, sex, sexual orientation, gender identity or expression, age, disability, ancestry, or national origin. By inclusion of sexual orientation, gender identity, or expression, of course, we are opening up Pandora's box. Some of the experiences we've had with the transgender movement in the state has suggested that there may well be individuals who would try to impose a particular gender ideology through our public schools. Many, there are parental associations, et cetera. And if this makes it to the ballot, then that'll be the next big battle. Renee, I know you've worked on this as well.
Right. I think something that we also need to be sure to make clear, because we don't know, I personally don't know who all the viewers are and what side of the spectrum they're on, but no group on this webinar believes in hatred or diminishing anybody or suppressing anybody's civil rights. The issue is that this so-called Equal Rights Amendment does not promote equality. It actually promotes inequality, and it's, again, specifically harms women. So people need to understand that the language that's being presented is really confusing. It's not clear, and this is not about equality. So that's why we oppose the Equal Rights Amendment at Minnesota Family Council. And certainly from a legal perspective at True North Legal have concerns about what the courts might do with this type of language with respect to the issues that we care about: life, family, and religious freedom.
And in fact, already the Minnesota Constitution includes Article 1, Section 2, that reads, no member of this state shall be disenfranchised or deprived of any of the privileges or rights secured to any citizen thereof, unless the law of the land or the judgment of its peers. We've got the Minnesota Human Rights Act that's at issue in the pharmacist case as well. So in this instance, we already have the protections that most people would anticipate when we say we need an ERA. But again, the language of this particular proposal is far different than the language of the proposal that came out of Congress a number of years ago, but failed to pass the states.
Thank you guys so much for being with us today. We are going to follow up. I'll follow up with some of the links. I know Renee mentioned their email address for True North Legal. We mentioned the Minnesota Alliance for Ethical Healthcare. We also have some one pages and other things that encapsulate a lot of what we talked about. So we will send all that out to anyone who registered in an email, and anything else that I missed, but I wrote down a few other things.
We will be also making this recording available. We've been recording this session, and notwithstanding some of the technological bumps along the road, we will make that available through the Pro-Life Center and our partners, who we thank: True North Legal, Minnesota Family Council, Minnesota Catholic Conference, Minnesota Concerned Citizens for Life, and Prenatal Partners, as well as Brian Gibson's Pro-Life Action Ministry. All of us, we are united for life, and as long as we keep the faith and persevere, I'm confident we will ultimately prevail. Thank you all for viewing.